Welcome to another edition of Crime News with Mark Solomon. It is Friday, September 24, 2021, and today we're going to be doing an overview on the state of affairs of the Laundrie Manhunt. We're also going to be doing a viewer question on how the affidavit for the arrest warrant in the Morphew case is going to be used in trial. Stay tuned. Brian Laundrie, talk of the news. Everything happened yesterday when the FBI got a warrant for his arrest. Let's take a look at that. The manhunt resumed in Florida wetlands, and the FBI issued a warrant over credit card activity. Remember, credit card fraud. That's where somebody uses a credit card against the owner's permission. And in this particular case, since Gabby Petito had been found to be deceased somewhere in the neighborhood of September 1st, give or take, what happened is the credit card use that Brian Laundrie used after that, assumedly, couldn't have happened with her permission. At least that's what the federal authorities are saying. The FBI got the warrant out of Cheyenne. Let's take a look at that. And here, credit card fraud in Wyoming after the death of Ms. Petito, his fiance, on a cross-country trip. And interestingly enough, he had originally been the person of interest in the investigation in her killing. And now the federal prosecutors went ahead and got that arrest warrant. One of the things I wanted to talk about was why. If he's going to be investigated for the killing, why would they want to go ahead and get a credit card fraud warrant? And the answer is so that they could take him into custody and begin the questioning process. Now, interestingly enough, if somebody is taken into custody, the first thing they're going to do, especially in a case like this with such national notoriety, they will almost certainly be getting an attorney, but it's possible they just may want to clear the air and give their story. So by getting a warrant, being able to arrest him upon sight, that means they can take him into custody by the federal authorities. The FBI can then potentially question him on Ms. Petito's demise. What I think it's worth explaining, this reminds me of a pretextual stop by a police officer. So in other words, let's say they think somebody might be driving under the influence, but they fail to signal for a turn, or if they're speeding, even by 1 or 2 miles an hour. That's what's called a pretextual stop. It's perfectly legal for a police officer to stop somebody or arrest them for something that they have the right to do, even though their completely legitimate and underhanded reason potentially is to investigate them for something else. That's perfectly legitimate. And there's no reason to say that a police officer can't stop somebody for a turn signal violation when they really want to see their demeanor, if they smell like they've been drinking, if they sound like they've been drinking, because that pretextual stop is legal. So in this case, when we look at an FBI warrant that was issued after presenting their case to a grand jury, there's absolutely nothing wrong with getting him into custody on something that they think they have a right to do. But the other thing I wanted to touch on too is the same reason that some people were talking about trying to arrest him for the use of her van, because after she was deceased, he presumably did not have her permission to drive it. Is that the same thing as car theft? And the defense to that is simply that he said, she told me I could do it. Same thing with a credit card. And so do I think that this credit card fraud case is going to stick? No, but it could, in the same way that he could be charged with the car theft. So let's talk a little bit about the difference between federal and state prosecutions. Because remember, if he was actually the one who committed her murder, and that happened in Wyoming, how could the FBI charge him with credit card fraud if he did it in Wyoming or one of the states on the way back to Florida? In federal law, they have the Commerce Clause, which I'll link to in the description. But the Commerce Clause basically allows the federal government to prosecute somebody for things that are done in connection with anything that affects interstate commerce, which is why if you steal a car and drive it across state lines, it can be federal. Same thing here. If he was using the car and the credit card while fleeing from a murder, that is potentially a continuing act which does affect interstate commerce because he did it over the course of several states, or at least two. And so that's one of the ways that I believe they're going to be looking to prosecute him federally, or at least to get the ball rolling on getting his story. Okay, let's take a look a little bit more at some of the other articles that have been coming out, like a number of articles that came out over the last couple of days about the arguments they had at a restaurant. Some of Gabby Petito's best friends are coming forward saying that they had jealousy issues and a toxic relationship. Not good stuff there. There's another article I found, since they are now looking for Brian Laundrie in this 25,000 square mile just absolute swampy wasteland of a place, just, and from what I understand, a lot of alligators too. But here is an article saying that Brian Laundrie is capable of surviving in the wilderness. And I think this is an interesting thing. But again, people talk about, is Brian Laundrie capable of self-harm? I know at one point we were talking about whether or not he was guilty. The media circus that this case has sparked really could go either way, as far as if he didn't do anything wrong and he left Gabby Petito in Wyoming where she met her end by somebody else, and he left, well, gosh, that's a whole lot of guilt for a guy to carry around, especially at the age of 23. And if he felt responsible for her death, even though he didn't cause it, that's something that he could also be dealing with. And if he did end up causing her demise directly, then again, at the age of 23 or any age, it could be something that he's wrestling with, and that could be something where he could be in for some sort of self-harm as well. A source close to the family said that he left the parents' home without his cell phone and wallet, which would really be the best way. If you're going to try to hide from the police, I guess it makes sense that you not bring anything with a GPS that radios its location back to home base, and at the same time, not bringing your wallet, not bringing your credit cards, debit cards, all of those things, which they certainly would have had a trace on first time he used it, just like the movies where somebody goes out, uses a credit card, and the SWAT team descends on the location within about 15, 20 minutes. So, if he's trying to stay away from the authorities, that's definitely the way to do that. Let's go ahead and get to this viewer question, because I think it's a really good question. And here's from Joe Blow. It was 2 days ago. And his question is, will the jury be able to read the Barry Morphew affidavit, or do they just get to hear the case as given? He asks because they didn't present the case so well during the pretrial, and if the jury reads this themselves, maybe they could comprehend better what happened. I'm scared he's going to walk, and it makes me physically ill. And I think that's a phenomenal question. And what you're really asking is, how is an affidavit for an arrest warrant used in a case, or is it used in trial at all? And the answer to that is, the jury is never going to read this affidavit for the arrest warrant, not in a million years. And the reason why is its entire purpose is to get the court to issue the arrest warrant. That's it. It is just fraught with hearsay, things that would never be allowed in trial. The person who writes the affidavit for an arrest warrant is the investigator, typically. Often they get help from the prosecutors to make sure that it has all the things in it that needs to be there so that the judge can find that probable cause that a crime was committed and that this is the person who committed it. And so when the judge got the affidavit for the arrest warrant, they found probable cause to issue the arrest warrant, which is essentially what the preliminary hearing is also, except the preliminary hearing is where the judge hears direct testimony as opposed to reading it in an affidavit. And at the preliminary hearing, the defense gets to cross-examine the witnesses and present witnesses of their own. So when a prosecutor presents their case to a jury, they have to call each witness who has personal knowledge of any of the facts that they want to testify to. The jury has a right to see those, and the defense certainly has a right to cross-examine them. So every single piece of fact that's in the affidavit for the arrest warrant or an affidavit for a search warrant can be challenged at trial by presenting the actual witness, and then the prosecutor can ask questions of the witness and the defense can cross-examine those and challenge all that information. It's not something that will ever come out by hearsay. In most cases, there are plenty of exceptions to hearsay, but when it comes to a trial, the jury would like to hear the facts from the source. And so that arrest warrant affidavit, great background information, and it's usually a great place to start on a case when trying to understand all the facts and issues and players and people and so forth, but not used in trial. So the affidavit that got the arrest warrant issued, the investigator had to swear to those things. So the only way it could be used in a trial is if the investigator or one of the witnesses is testifying and says something different than what's in that affidavit for the arrest warrant, because then the defense attorney could potentially use that arrest warrant as a prior inconsistent statement, and then the jury can hear that the person has changed their story between the affidavit or the arrest warrant and their testimony right then in trial. So it can be a good impeachment device, but it's not going to be something that the jury's ever going to read. Not just because it's so long. It could be literally 2 paragraphs for an arrest warrant affidavit, and the jury would never see it. But they could hear some of the statements if it was being used to impeach. I hope, Joe Blow, I hope that answers your question. Really good question. I appreciate that. So that is it for today. If you have any thoughts, feelings, or questions that you'd like that we haven't addressed yet, please put them in the comments below. And until then, thank you so much for watching.